without further ado, I do want to introduce our wonderful guest speaker today. Today we have Stacey Gordon Sterling with us, and she is the Animal Law Program Director at the Animal Legal Defense Fund. And there she builds educational programs for law students to expand and strengthen the cadre of animal law attorneys, advocates, and activists needed to protect animals using the legal system. So for those of us who were here last week, you see how, the missions sort of overlap there, and that basically what we're trying to do is not only work with the system that we have, but also advocate for a better legal system that accomplishes these goals that we're trying to accomplish. So she brings her academic background and a passion for legal advocacy to the Animal Legal Defense Fund team. She holds a BA in English and creative writing from Eastern Washington University, a Master's of Library and Informational Science from the University of Washington, and her JD from the University of Montana. And she has received the Ken Sugar Humanitarian Award from the Humane Society of Western Montana and the Montana Faculty Service Award. So she brings a lot of really amazing credentials with her today, and she is definitely the right person to be going over this topic with us. So again, without further ado, I'm going to hand things over to Stacey Gordon Sterling.
Thank you. Thank you. I would like to thank Professor Stewart for, am I on? Okay, good. I always think, oh wait, maybe I don't actually have my audio on. You'd think I've done this enough by now. Anyway, thank Professor Stewart for inviting me to participate in this today. I have to say I really like the idea of ecological immersion and learning out in nature, and I'm really sorry that we can't do that right now this year. But I do hope that what we talk about today, the ideas that I talk about in the discussion we have, will kind of help frame your experience differently next time you do get to go out in nature and interact with wildlife. I am, like I said, I'm very happy to be here. I did spend 20 years, before I joined Animal Legal Defense Fund this year, I spent 20 years teaching in law schools. I was a librarian and a professor in law schools, so I'm excited to kind of get to be back sort of in the classroom a little bit from time to time. So thank you for inviting me to be here today. Before we start off, there is kind of one terminology kind of thing I want to talk a little bit about, and that is the term animals. Of course, animals includes humans, and so often when we're talking about human and non-human animals, we do use the term non-human animal. That is a mouthful to say over and over throughout a whole presentation. So I am just going to use the word animal to refer to non-human animals today, which is ultimately what I'm talking about. The other thing, of course, we need to define when we're talking about animal rights is what is it that we're talking about when we talk about animal rights? And again, we have a couple of different terms that tend to come up in law when we're talking about animal rights. And interestingly, sometimes these terms are conflated and sometimes they're used in opposition to each other. So it helps to understand both what animal rights and animal welfare are and what we are actually talking about today. In some ways we think, oh yeah, these are easy terms to define, but it turns out that as they've been used both in social movements and in the legal system, they're not as easy to pin down. Animal welfare is probably the easier one to pin down. Usually when we use that term animal welfare, we are talking more about moral protections for animals. In other words, we have laws that provide for better treatment of animals because it's the right thing to do. And they include kind of the underlying ideas of compassion for animals, of respect for all of life, of well-being for individual animals, of the animals, of keeping animals free from unnecessary harm, captivity, and pain. And think about that word unnecessary, because that often actually is a big part of the animal welfare discussion. More recently, that term has been used as there have been more kind of polarization within how we treat animals and within the social and legal movements, sometimes the term animal welfare has been used to sort of preserve human domination over animals as long as we are providing for their welfare. In other words, humans can still use animals, and you think about things like animal testing and research and using animals for food. Humans can still use them as long as we provide in some way for their welfare. Some harm will still be allowed to them. And so truthfully, right now, when you look at animal welfare and that term, it is used both ways. Often used both ways, although sometimes now movements that used to talk about animal welfare in the sort of moral protection sense use the term animal protection instead to kind of make a difference there. So the other term, animal rights, has come to be more thought of as more of a radical idea, a radical social movement, because it would involve legal recognition of power, privilege, and forcible interests, just like, you know, any concept of rights. So it's still helpful to think about when we use that term, what are we saying? Actually, originally the term animal rights meant moral rights. It had more of the connotation of what I just talked about of animal welfare now. So the original term was more an ethical kind of sense. Now, when we use animal rights, we are thinking about it more in the sense of legal rights for animals. There's a lot left open there, however, in this discussion, and that's a lot what both legal and social movement around animal rights are grappling with, is which animals are we talking about? All animals, only some animals? And we'll talk about this a little bit more as we go through. What rights are we talking about? Do they have exactly the same rights as humans? Are there some different set of rights that animals would have? And what is the source of those rights? Are they inherent to animals? Are they a function of statute? Are they a function of constitution? Where do the rights that animals might have come from? So all of that kind of goes into the idea of animal rights. And those questions are far from settled right now. So I'm hoping that when we get to the discussion and the questions later, we might be able to talk about some of that. Okay, I am not going to give you a primer on constitutional rights. In fact, I'm pretty sure my constitutional law professor would say that I have no business doing that. But I do want to talk a little bit about this article that was written by Lawrence Tribe, actually quite a while ago now, but because I think he provides a really good framework for talking about animal rights within the broader concept of rights in general. One thing you'll notice on this slide is that I actually quoted from his article because I really like the way he phrased things. You'll also notice that although the title of the article is 10 lessons on constitutional experience, I abridged it to 7 lessons for the purposes of this discussion. So I do encourage you to read this article later, and I do have a slide later on that has citations to the things I discussed today. Okay, so first of all, the first thing he says about animal rights, and this does kind of go right at the controversy about the animal rights movements, both legal and social again. Rights are not really that scary to confer because they're never absolute. I mean, we think about you can't yell fire in a crowded theater, right? Free speech does not really mean you can say anything you want anytime you want. And so more what he talks about here is rights are not absolute, and often there is a balancing that goes into, you know, animal rights versus the rights of humans. There would have to be a balancing there. And in fact, he does talk about the instance of what if the only way to relieve some horrible human suffering were to do some experiment on chimpanzees. It doesn't, animal rights wouldn't necessarily mean you can't do that. Animal rights, although it could end up meaning that, but animal rights would mean that there might have to be a balancing of the interests and the discussion. Animal rights would mean that the chimpanzees' interests would have to be considered in that. And just like we balance rights that different people have. But he does then go on to say that taking rights seriously does mean that you would have the things like unnecessary pain, cruel treatment would be precluded. And again, we get back to that word unnecessary. And in fact, some people say that this is the ultimate goal of animal rights, is the preclusion of unnecessary restrictions on liberty, painful, cruel treatment, things like that. The third one, and this one we know, but we often forget. Our legal system does accord rights to other entities other than human beings. We think of corporations are legal persons, ships are legal persons, churches are legal persons. So saying that animals have rights, and when we'll talk a little bit later about legal personhood, it doesn't mean that they are human beings. It means that they are legal persons, which is a completely different concept. Tribe says that largely the idea of who is a legal person is cultural. It's an idea of acculturation. So we could get used to the idea of animals being legal persons, just like we are completely used to corporations being legal persons and having some rights therefore. So essentially then, the assignment of saying you have rights, you are a legal person is fictional. They're not really a human within the legal system. Nevertheless, those rights do mean something. And when we talk about, one, there is a recognition of rights, but two, we'll talk a little bit about standing later. Once the legal system recognizes rights, they also have to recognize a way to enforce those rights. So it isn't, recognition of rights isn't meaningless. But then he goes on to say rights aren't all they're cracked up to be. And we know that rights have to be enforced. And sometimes the way rights are given is less you have the right to do this and more somebody else is prohibited from doing something to you. And so there's a distinction between the rights there. Those rights are, some rights are stronger than other rights. Often when we think about rights, we think about constitutional rights. We think about all rights coming from Constitution, but truthfully, some rights come from statutes. And if you think what I just talked about some rights really are a prohibition against what somebody can do, think about animal cruelty statutes. They prohibit people from treating animals in certain ways. And so in a sense, they give animals a right not to be treated cruelly, but really it is a prohibition rather than an inherent right. But they are strong. They can be strong rights for animals. This next one is interesting, and we've touched about it a little bit when I asked the question of who would get animal rights, which animals would get rights. And when we look a little bit later about the work of the Non-Human Rights Project, and also some other discussions on human rights and who should get legal personhood on animal rights and who should get legal personhood, a lot of times the discussion is around animals that can show human-like qualities, intelligence, cognition. And then the question becomes, so how intelligent do you have to be to get rights? What level of cognition do you have to be able to show? And it becomes an unanswerable question. You know, it would always get to be finer and finer degrees of intelligence, cognition, whatever standard you were using. And so Tribe points out that trying to find that kind of test, he uses the phrase tilting at windmills. And we'll discuss that certainly while some movements are attempting to do this, others are kind of putting the baseline at all sentient animals. All sentient beings should be able to fall under this category of having animal rights. Okay, so kind of with that background, what we're going to talk about today. One, we're going to talk about legal rights for animals. Of course, we're going to touch on animal welfare as we go through, but what we're really talking about are legal rights, and particularly in the context of wildlife, but that includes captive wildlife. So really, in the legal system, animal welfare and animal rights are ultimately probably two means to the same end, protecting the physical and emotional well-being of animals, and their ability to flourish in their natural environments too, when we're talking about wildlife. Animal rights, the animal rights movement, the legal personhood movement is maybe a more direct route. The animal welfare movement within the legal system is working within the legal system the way it is, and also hoping to evolve the legal system. But ultimately, the idea, the purpose is the same. But we are going to talk more about that legal rights idea today. Okay, so let's look at the legal system now, and how animals are treated in the legal system now. So ultimately, any discussion of legal rights for animals has to be based on this human-created legal system, because that is all we have. That's what we're working in, as a human-created, truthfully human-centric legal system. Even where human rights are maybe considered to be inherent rights, fundamental rights, there has to be a legal system to recognize and enforce those rights. Same with animal laws or animal rights. First of all, at this point, we need a legal system to kind of bestow those rights on animals. But also there would have to, the legal system, both legislative and the court system, has to recognize and enforce those animal rights. So we need that legal system to give and enforce those rights. But right now, the legal system does present a couple of hurdles, probably more than these two, but these are the two that I want to talk about: the legal status of animals and also the standing of animals within the legal system. Okay, legal status of animals. Very dignified tiger there. The reality is that animals are property. Animals under the law are legal things. Mostly this is a common law concept that goes way back in legal history, well before the founding of the US legal system. In fact, the idea that animals were property has been well ingrained within our common law legal system. And at that time, when animals there was no concept of pets. And so we often, animals were livestock. They were somebody's property. Interestingly, although, property denotes the idea of legal things, and that is exactly right, animals are considered legal things. When we think about it, that's not how we usually think about animals. We don't think of our companion animals as things. Often we think of them as family members. I used to, when I still worked at the law school, I used to walk through the library and see how many students had pictures of their pets up on their laptops. Other students had pictures of their kids, but this same thing. It was either their pets or their kids. We think of them as family. We think wildlife we don't think of as things. They're wild. They're part of nature. But we don't think of them as things. And generally, the only time we think of animals as property is with livestock. But legally, all animals are property. They are legal things. And the difference between a legal thing and a legal person is that a legal person has the ability to possess interests that can become rights. So that's why this is such a big issue in the legal system as far as animals. If they are things, they are not considered to have any interests that can translate into rights. They are somebody else's property, and the people are the ones that hold the interests. Interestingly, although this is a fundamental in the legal system, animals are legal things, they are property. But interestingly, we have all these laws that more track how we think of them than how they would be treated if they were truly considered to be property. So think about, in many places, animals can be crime victims. And animals must be given a basic level of care. There are no laws that say you have to care for your dining room table a certain way. But there are laws that say that animals have to be given, basic food, shelter, medical care. Think of hot car laws. Those are, and these often apply to children too. You can't lock an animal in a hot car, and in some places, some people can break into a car to rescue an animal that's in distress. I was reading an article that talked about this and made the analogy that there is no similar law for ice cream. It's going to melt. It's going to be destroyed in a hot car, but there's no law that says you can't leave your ice cream in a hot car. There are laws that say you can't leave your living animal in a hot car. The Pets Act after Hurricane Katrina that now requires that states that get federal funding have to include animals in their evacuation and disaster plans. Again, nothing like that for property. And now, and this is a more recent development that is coming out of the fact in dissolution, because animals were legal things and property, technically they should be treated under the property division in a divorce. But that doesn't work, and courts weren't really doing it that way. And so more and more, 3 states now, but I think others will, of course, catch on. More states are starting to, in their dissolution laws, say that with animals, they're not taking away their status as property, but they are saying that you do have to consider the interests of the animals. So they are giving animals some interests right there, while at the same time still trying to retain the idea that animals are property. So the legal system, even within this kind of fundamental baseline of animals are things and are property, is starting to write laws that that actually consider, okay, they might be property, but they're a different kind of property. Okay. And so that gets us to, so if the status of animals within the legal system is a hindrance to animals having rights, what are the alternatives? And one alternative, and the one that is probably the one that you hear about the most, is the idea of giving animals legal personhood, which again is not saying, okay, now they're human beings. It is saying legally they are persons. And you think of statutes that refer to the word person. And again, we're going back to corporations are legal persons, ships are legal persons. So that's what we're talking about. Sometimes this is called the abolition movement, because it is the idea of abolishing the property status of animals. But again, and this is where some of the questions come in. So with the movement right now, it's not necessarily applying to all animals. A lot of the cases so far are arguing that animals like chimpanzees, elephants, whales, kind of megafauna, but also animals that can demonstrate a certain level of cognition and intelligence, that those are the ones that should be legal persons. And probably one of the reasons that they are arguing this way is because those are the easiest arguments to make in court, right? So we're working within a legal system that exists to change that legal system. But there, of course, are another way to look at this, and I did mention this before, is that there is a lot of research now, scientific research now, about sentience of animals. Are aware, can feel pain, and all of kind of other factors that go into a determination of sentience. And so there are others that argue, no, it should apply to this legal personhood status, should apply to all sentient beings. Does that mean that all sentient beings would have to have exactly the same rights? Probably not. That would probably be unworkable. And so essentially you're looking with legal personhood about animals, whichever animals it ends up applying to, hold rights that protect their individual interests, but still it's not clear what those rights would necessarily be. That, I would still argue, isn't really such a scary thing, because courts are used to doing that, right? Courts are used to saying, of making those determinations of how individual facts apply to laws, apply to legal precepts, constitutional ideas, everything. So courts are used to doing that, and none of this is saying, okay, we're going to immediately have animals are now legal persons and we know exactly what all their rights are. Just like everything within the legal system, it would take time to develop that system of animals having legal personhood and the rights that go along with legal personhood. Another alternative to this has been proposed by David Faber, who is a animal law scholar, premier animal law scholar, and he suggests, instead of abolishing the property status of animals, of creating a fourth category of property. So right now we have real property, personal property, and intellectual property, and he suggests creating a category of living property. And he does define which animals in his proposal, which animals that would apply to, and he does apply vertebrate animals. And he is specifically talking about animals that are either named, like we name our pets, or that have some kind of group reference, like wildlife, something that's probably too big of a group reference, but something identifiable, because those are the animals that we have some relationship with and want to give some sort of legal status to. So he is suggesting this living property concept. And he's saying that within this concept, then, animals, one, would hold some rights of their own, but those rights would be, well, one, those would be limited, but also the rights of the owners of those animals would be limited to accommodate the fact that animals do have some rights. And even the rights of non-owners would be limited because of this idea of living property. So that's kind of a an alternative to the legal personhood status. Truthfully, other than I have not seen that idea argued in any court, and what we'll talk about later is that this idea of legal personhood has been litigated and is continuing to be litigated in courts. But just I wanted to raise that idea of what alternatives are possibly out there to the idea of animals being things under the law. Okay, so another issue with our current legal system is that in order to bring a case within the court, in order to have the courts ask the courts to enforce a right or a claim that that you have to have standing before the court, which is essentially the ability to seek legal redress for violation of rights and interests. And so one question that comes up is, can animals have rights? And some people say that animals do have rights now, that things like animal cruelty statutes, the Animal Welfare Act, the Endangered Species Act, all of those, they say they give animals rights, but the question then becomes, but wait, do animals really have rights if they don't have any standing in court to seek enforcement of those rights? So again, I'm not going to give you a primer on standing. Turns out standing is a complicated legal issue, but we will talk a little bit about it. I just want to touch on some issues, particularly how they apply to the idea of animals having standing to enforce rights, even if they were given those rights. So essentially, three elements of, and you probably heard these before, three elements of what we call Article 3 standing, of constitutional standing, which essentially all standing does is make it so that the courts are only hearing actual controversies, actual cases, as opposed to deciding theoretical issues. So under an environmental law case, actually, Lujan v. Defenders of Wildlife, the Supreme Court set out these three elements, that there has to be an injury, in fact, that is concrete and particularized and actual and imminent. There's a causation element. The defendant, there has to be a link between the plaintiff and the defendant in the case that's not broken by a third-party cause. And the idea of redressability. If the court holds in the plaintiff's favor, it has to be more likely than speculative that will solve the problem, that the plaintiff's interests will be restored. So a lot of when we're talking about animals, it is this question of this issue of injury, which is where a lot of the jurisprudence surrounds. So essentially, that injury element means there has to be, the plaintiff has to have a personal injury, has to be personally injured in order to bring a case, in order to have standing. So that issue of person is important here, and basically it has been held to mean person, not animal. So there has to be some person who is injured by whatever injury there is to the animal, and it is not enough that I say I want to protect animals, that is my mission. That is not enough to claim that, to bring a case on behalf of an animal. I have to actually be personally injured by the injury to the animal, which is a pretty big hurdle to get over. Now there are a couple of ways that this does play out. One, when I say person, again, that person can be a legal person. So it can be an organization. And, which is why we see all the time, well, organizations like the one I work for, the Animal Legal Defense Fund, can sometimes show standing to argue in court on behalf of animals, but that is because their organization, and more precisely the members of their organization, actually do have some personal injury. And where this can come in is that injuries can be aesthetic injuries. And so one important case where this plays out was an Animal Legal Defense Fund case, Animal Legal Defense Fund versus Glickman, where one of the things that the court held was one of the plaintiffs had an extensive background in wildlife biology and in animal protection and investigation of animal crimes. He went often to a zoo to kind of interact with the primates there. It was a small zoo, I believe, and went often to interact with the primates and was distressed at their treatment. And the court held that that was an aesthetic injury, that he was personally injured by the way that the primates were treated. Okay, so another idea, though, that comes into standing is with statutes. And often where animals, even if they do have interests, in which some people argue are rights, even if they do have interests, those come from statutes. And so where there is a statute at play, another element to the standing is that the court has to inquire whether Congress, or on the state level, the legislature, but Congress intended to confer status or standing on the plaintiff. So there's a couple ways that can happen. One is with citizen suits. And this happens with environmental statutes. Some of them say private citizens can sue to enforce this statute, which is great. Then they have standing as a citizen because the statute says they can. Only the Endangered Species Act is the only animal protection statute. That's the only one that has a citizen suit provision in it. So, okay, good. Individual citizen can sue to complain about violations of the Endangered Species Act, but it still has to be a legal person. And in the case Cetacean Community versus Bush, the court actually went through statutes like the Marine Mammal Protection Act, NEPA, the Administrative Procedures Act. Sorry, I don't know why that was so hard to get out. They went through those and looked at the terminology in those and said, no, Congress referred to person. If Congress had wanted to give animals standing under these statutes, they could have done so plainly, but they did not. So they're saying, the court is saying there's no reason that animals don't have legal standing or can't have legal standing. It's just that Congress has to do that. They have to expressly give them legal standing, and they haven't. The other idea is that absent citizen suit provisions, which, like I said, most statutes don't have, then the plaintiff has to fall within the zone of interest that Congress intended to protect. And this is an interesting idea, again, with animals. And again, going back to the Glickman case, because here the court did find that the Animal Welfare Act, as it applies to exhibits and like zoos and like zoos in this case, that there was an element of the Animal Welfare Act that intended to protect people. And you can see I have this quote here: the purpose of animal exhibitions is to entertain and educate people, and they make no sense unless you take the interest of the human visitors into account. And so therefore they said the plaintiff in Glickman did fall under that zone of interest of the Animal Welfare Act, of viewing animals in a humane condition. So they did allow standing in that particular case based on that zone of interest. Truthfully, it doesn't always work out that way. The jurisprudence does tend, under the zone of interest test, tend to be pretty narrow, and it has been particularly hard for organizations and their members to show that they do fall within that zone of interest of any of the animal protection statutes. Interestingly, there have been a couple of cases where the Ninth Circuit did suggest, oh yeah, animals can have standing. And of course, the Supreme Court has said, oh yes, animals can have standing. It's just that Congress has not given it to them. A couple of these Ninth Circuit cases, well, one in particular, just kind of said, oh yeah, animals have standing. But then later and then there were cases that were based on that, but they kind of pulled that back later and said, oh no, that was really dicta. And really only one person has to have standing, and there was a human person that had standing in that case. And so this was just kind of a rhetorical flourish, they actually called it, and we didn't really mean that animals have standing, which was unfortunate because it looked for a little while like, hey, that's a really good thing. They say that animals have standing, but no. Okay, so that's standing. So right now where we are with, even if we have statutes that arguably give animals rights, where we are is that there has to be a person, can be an organization, but has to be a person that is personally injured, and that either directly has the right under a citizen suit or that falls within the zone of interest to have standing to even bring that case. So let's look now at how some specific cases and ideas about how these concepts play out. So some of you may have heard of this case, the monkey selfie case, Naruto versus Slater. If you haven't, just really briefly, photographer was in a nature preserve, I think in Rwanda, but I can't remember that exactly. Left his camera out, monkey picked up the camera, was playing with the camera, took a picture of himself. So of course it was, that picture was on the camera, took several pictures of himself, and those pictures, then the photographer essentially disseminated those pictures. And then a couple of, this case was actually brought by PETA, by PETA as next friend for the monkey, saying, well, no, the monkey took the picture, the monkey should hold the copyright and be able to financially profit from the sale of those pictures. So the first thing the court did was pretty much brush over and say, okay, yes, the monkey has Article 3 standing. They meet those three elements of injury, causation, redressability. That's in like one paragraph, which truthfully kind of surprised me given how controversial the idea of giving an animal standing would be. But I think they were able to do that because they also found in the very next paragraph, and a little bit more discussion, that we're talking about a statute here, the copyright statute. So we need to look and see, is there also this prudential standing? One, they'd said Congress did not plainly grant animals standing in the copyright statute. Of course, we know that. But then two, the language of the copyright statute shows only an intention to protect human interests in intellectual property. So, and they were looking at things like the statute refers to things like heirs, and who copyrights pass on to. And of course, animals don't get married and have heirs. That's what they said. And so that shows that the copyright statute was intended only to apply to animals. So there was no prudential standing, even if there was Article 3 standing. So monkey did not have standing. The other issue, though, that came up in this particular case was because this was an attempt to show not that the organization was injured, but that the animal was injured and the organization was just representing the animal's interest as next friend, which next friend is a statutory concept. Next friends are granted to essentially to someone who cannot press their own interests in court, usually, and they are granted by statute to prisoners, minors, and people who are considered legally incompetent. Humans who are considered legally incompetent. And someone who is seeking standing as a next friend, as PETA would have been doing in this case, has to be able to show that, one, the plaintiff can't legally litigate their own case. So that part is pretty easy in this. The monkey cannot show up in court, argue his own case. And two, that the next friend has to have a significant relationship with the person that they are representing, essentially. And the reason for this is to prevent somebody from basically trying to press their own interests by going into court and saying, yeah, this is the person who was injured and this is what they would want. With the idea of the relationship element in the next friend jurisprudence is that the next friend has to have a significant enough relationship to be able to determine and understand the goals of the actual plaintiff. So here the court said, we can easily see humans can understand the interests of another human, and especially if they know that person, right? And so their threshold question was then, can any person, human person, determine whether a monkey wants to hold a copyright? And of course they said, no, a human person cannot determine that. So they can't meet that element, that relationship element, so they cannot have next friend standing. So essentially, monkey doesn't have standing, next friend doesn't have standing, so there's really nobody to press this case. And this is maybe something that we can talk about a little bit later. I sort of feel like this decision was, of course, it was based on the facts presented to them. Sure, nobody can determine whether a monkey wants to hold a copyright, but what if the issue were more about the liberty or well-being or the survival of the animal? There, as humans as sentient beings, I think, can probably make that determination as toward the interests of another sentient being. So the court, of course, had to work in the facts they had, but I'm not sure that determination, that next friend determination, really would hold under other facts, or I would argue that it wouldn't, shall we say. Okay, so that's one instance where this comes into play. The Non-Human Rights Project, some of you may also have heard about their work, and actually their mission and their objectives here I just took off of their website. And this is the litigation I was mentioning, that going toward legal personhood for animals, and that is exactly what they are trying to litigate. They are, and have been since 2013, filing habeas corpus cases on behalf of captive chimpanzees initially, and then adding in elephants, arguing that, and with the chimpanzees arguing a lot of what I talked about, the intelligence, the cognition of chimpanzees, and how similar they are to human beings, and so they should be able to hold these rights as legal persons and no longer be considered property but persons. So far they have had, I did not mean to go ahead. They've had several cases that have gone through both the New York and Connecticut legal systems, and so far nobody has granted habeas. None of the courts have granted the habeas corpus petitions on behalf of either the chimpanzees or the elephants. But what I think is actually some pretty remarkable language has started to come out of these decisions that these courts are making. And actually, I'm going to read you. I don't usually do this, but I really like what the court said here. And this is kind of a long passage, but I'm going to read it to you anyway. This is from the New York Court of Appeals Judge Eugene Fahey in one of the chimpanzee cases that was before it, and this is from 2018. Okay, so he says, and this was in a concurring opinion. So he actually concurred with the judgment that in the court's decision of not granting the habeas corpus petition, but in his concurrence he said, the question will have to be addressed eventually. Can a non-human animal be entitled to release from confinement through writ of habeas corpus? Should such a being be treated as a person or as property, in essence a thing? The inadequacy of the law as a vehicle to address some of our most difficult ethical dilemmas is on display in this matter. The appellate division's conclusion that a chimpanzee cannot be considered a person and is not entitled to habeas relief is in fact housed on nothing more than the premise that a chimpanzee is not a member of the human species. I agree with the principle that all human beings possess intrinsic dignity and value and have in the United States and territory completely controlled thereby the constitutional privilege of habeas corpus, regardless of whether they are United States citizens. But in elevating our species, we should not lower the status of other highly intelligent species. The better approach, in my view, is to ask whether a chimpanzee fits the definition of a person or whether a chimpanzee has the same rights and duties as a human being, but instead whether he or she has the right to liberty protected by habeas corpus. That question, one of precise moral and legal status, is the one that matters here. Does an intelligent non-human animal who thinks and plans and appreciates life as human beings do have the right to the protection of the law against arbitrary cruelties and enforced detentions visited on him or her? This is not merely a definitional question, but a deep dilemma of ethics and policy that demands our attention. To treat a chimpanzee as if he or she had no right to liberty protected by habeas corpus is to regard the chimpanzee as entirely lacking independent worth, as a mere resource for human use, a thing that value of which consists exclusively in its usefulness to others. Instead, we should consider whether a chimpanzee is an individual with inherent value who has the right to be treated with respect. The reliance on a paradigm that determines entitlement to a court decision based on whether the party is considered a person or relegated to the category of thing amounts to a refusal to confront a manifest injustice. Whether a being has a right to seek freedom from confinement through the writ of habeas corpus should not be treated as a simple either-or proposition. The evolving nature of life makes clear that chimpanzees and humans exist on a continuum of living beings. Chimpanzees share at least 96% of their DNA with humans. They are autonomous, intelligent creatures. To solve this dilemma, we have to recognize its complexity and confront it. In the interval since we first denied leave to the Non-Human Rights Project, I have struggled with whether this was the right decision. Although I concur in the court's decision to deny leave to appeal now, I continue to question whether the court was right to deny leave in the first instance. The issue whether a non-human animal has a fundamental right to liberty protected by writ of habeas corpus is profound and far-reaching. It speaks to our relationship with all life around us. Ultimately, we will not be able to ignore it. While it may be arguable that a chimpanzee is not a person, there is no doubt that it is not merely a thing. So, I read this language initially as taking the jurisprudence or demanding that we take the jurisprudence in a new and what I thought was a really hopeful direction. my question, and this is another one maybe we can get to in the question and answer and discussion time, is his language here just limited to chimpanzees? So ponder that a little bit. Okay, another idea, and this one really is an idea. It is not anything that has gone through the courts yet, but it is really an interesting idea based on this idea of animal welfare and animal rights. And essentially, and this is one that is promoted by Karen Bradshaw, who teaches environmental law, I believe, at the University of Colorado. And she proposes that animals should be able to hold property rights. And particularly what she is thinking is property rights at the ecosystem level. So, and we're talking about wildlife here. And what she says is that really, when it comes to wildlife, and she brings in aquatic sea life too, neither the animal welfare nor the animal rights movements and approaches are really protecting them. Because what the biggest danger to wildlife, to sea life, is loss of ecosystem. And that is what is causing extinction. I don't know why I couldn't think of that word. And what is really endangering them is that loss of ecosystem, which really neither the animal rights nor the animal welfare approaches are really addressing. So she is arguing then that animals should be able to hold those real property rights, and which would preserve for them a permanent habitat and protection within that habitat, and then also create the property rights under our system. Of course, it would have to be managed by humans, but those humans would have fiduciary duties to manage in the interest of the animals. And actually, so this article, I'm just hitting the high points of the article, and the article is quite detailed and really does consider the things, well, about, okay, so how do you know that the human trustees are really going to uphold their fiduciary duties and not manage really for in human interest, but really in animal interests? And so one thing that she proposes is that there would be some sort of a certification body that would certify the trusts that acted in the interests of the animals, and those trusts then would have a certain set of standards that are established by biologists and scholars and lawyers and everybody by biologists and scientists who would presumably be able to determine the interests of the animals, and then those trusts would have to be managed that way. Now, interestingly, she does say we are only talking about wildlife here, and that it would not grant animals, her proposal would not grant animals any other rights other than this right to hold property. And so really this proposal shouldn't be considered as a proposal all by itself, that this is going to solve all the problems, but is something that should be considered as kind of complementary to the what's going on now within the animal welfare and the animal rights movements in the legal system. But really, what it is meant to get at is both habitat and species conservation by giving animals property rights. Which again, I'm definitely not going to give you a primer on property, but if you think about how central property is to, and the property law is to our legal system, giving animals even those limited property rights would be pretty astounding and is a pretty interesting idea. So I really here only hit the main points of her article, and I did provide the citation for you. I really recommend that if you're interested that you read this article, partly because of her proposal, but also because it is contains a really interesting discussion about both the animal welfare and animal rights movements, and is really very thoughtful about both the positive and negative aspects of both of those movements and where they do well and where they are not adequate. And then actually, she's also very thoughtful about the positive and negative aspects of her own proposal here of animals being able to hold property rights. I raise it here because it is a really interesting idea of how do we solve this issue for animals if they don't have these rights in our legal system to be able to protect their own ecosystems, which is, in other words, to be able to protect their own survival. Okay, so one last thing I want to talk about is what are other legal systems doing with regard to animals and animal rights. It's not just the U.S. legal system that is admitting, sorry, I've just read the word admit on my screen. It's not just the U.S. legal system that's grappling with these issues. And in other cases, in other countries, in other legal systems, they've gone kind of different directions than what we have, based on their constitutions, on their the foundations of their legal systems. So this is certainly not all of them. This is just kind of a smattering. And recent ones. One of the first ones you may have heard about this was in India. One of their state high courts that essentially declared that all animals are legal persons. And when they did this, they issued directives both to individual citizens and to kind of like municipal governments to protect animals, and also declared that all citizens have a responsibility, they have a duty to protect animals and ensure their welfare. So that was pretty sweeping. They didn't necessarily say, okay, now animals are legal persons, they have all these rights, but they did say they are legal persons, which means all of a sudden, okay, if they're persons, they have ability to enforce these enforce rights that kind of go along with the fact that others have responsibility to protect their welfare. Very recently, in Pakistan, and very recently being this year, the Islamabad High Court held that animals do have legal rights. They didn't just say animals are legal persons. They did say animals have legal rights. And this case is actually about animals, mostly it was about animals that were captive in a zoo, but there was also a case that was brought into it about how street dogs were being killed. And interestingly, excuse me, particularly the part about animals in zoos, the decision that animals have legal rights was not necessarily based on the inherent legal rights of animals, although the court does talk about the inherent legal rights of animals. What it was ultimately based on is the constitutional human right to life. And the court said human life is dependent on wildlife and on the survival of wildlife. Therefore, under our Constitution, animals have these rights because humans have these rights. So it was a really interesting decision, not necessarily based on the rights of animals, but based on the rights of humans. But it's still, even though that was the basis for it, the decision, and then one that followed up, and an order that followed up after it, contains this really great language about animal sentience and the natural rights of animals. The court is highly critical of human treatment of animals, and particularly of captive animals. Both decisions, and some really beautiful language about wildlife flourishing in its natural environment, and what humans have done by holding animals captive. And actually, if you read the story about the elephant, it's a pretty sad story about an elephant who's basically was banging his head against a wall because he was all by himself. And elephants are very social animals, and he was in distress. Now has been released to a sanctuary because of this case. These next four are actually, and I went backwards in time, partly because these four are not specifically about animals, but they are about the nature's rights and ecosystems rights, and they don't preclude the rights of animals from within those ecosystems. So one of the early ones in 2008, Ecuador recognized nature as a legal person, and it was broad, nature, and you can see there, nature is a legal person, and they did set out they have the right. Right to integral respect for the existence of nature, for the maintenance and regeneration, structure, functions, evolutionary processes, so all of that. So that is a pretty broad right kind of just survival for nature as a legal person. There actually have been cases brought under that particular, brought after that particular decision. One was against a mining company, I remember. And then following suit in Bolivia in 2010, Bolivia actually, it was not a court decision, it was, they amended their constitution to recognize the rights of ecosystems. And then in 2012, they expanded that right to elevate the rights of nature as equal to the rights of humans. So of ecosystems have the same rights of humans, which doesn't mean they have human rights. It means that their rights as an ecosystem are on the same level. And so when you're doing the balancing, it's not one is more important than the other, but they have to be in balance together when they're balancing rights. Again, fairly recently, a few years ago, New Zealand in 2017 granted legal personhood to a river. And this actually was an interesting case as well. And then going back to India and talking about rivers, before the case, the court that declared that animals are legal persons, a year before that, that same court decided that the Ganges River and the Yamuna River are both legal entities. So again, it is interesting, and I raise these more as ideas of how our ideas about animals and nature and our legal protections for them and what protections they deserve, they are starting to, the jurisprudence is starting to change. These ideas are getting embedded in our legal system because people are bringing the cases. So that decision in Pakistan in the Islamabad High Courts actually cites the Non-Human Rights Project litigation. And they brought those ideas into their decision. So it's encouraging to see these change. And I go back, I think back to Lawrence Tribe saying, the idea of giving animals rights is more of one of acculturation, that we can do that if we want to, and it's just kind of getting there. So, okay, I have no idea how long I've been talking. Well, not too bad. Okay, so I really should have provided a handout here, and in fact I will, now that I think about it. I will collate all of these articles and send Professor Stewart kind of a handout that she can email out to all of you. These are some of what I used when I was researching this, but also just some things I know about. There's actually a ton of stuff out there, not just in the legal literature, some interesting things in human rights literature about animal rights that I will add to this. Okay, so I didn't save as much time as I wanted, but I did save like 15 minutes for questions and discussion. So I would like to open it up now for that. I looked at this slide earlier and thought, wow, that wolf looks like I'm daring you to ask questions, which not meant to be a dare, but I am hoping that you have questions or issues that you want to discuss.
So we actually have already quite a few questions in the chat that Mr. Keene and I will share. If anyone else has questions at this stage, just raise your hand and we will unmute you. We're going to start with the ones in the chat and hopefully get through everything. Luckily, our first question was, are there other legal systems around the world that the American legal system can look to as guidance? And we just covered that. So the next question is, and it goes back to a little bit earlier in the discussion, how do we protect species that are not sentient but play a key role in the ecological structure of species that are of higher intelligence? Doesn't it create a sort of domino effect because a failure to protect those species goes against the mission to protect the rights of sentient species?
So, yeah, that's exactly right. I mean, you can't, and that does kind of go back to the idea of ecosystem protection, right? You can't protect animals, wildlife, if you're not protecting their food source as well. And so some of that, and to some degree, we do have some, again, laws, statutes that protect non-sentient beings. You know, if you think of environmental statutes that protect them, but not to the level that they're giving them rights. And that does go back to the idea of standing, of who can enforce these statutes in court. And that's where a lot of the environmental standing does surround, like, who exactly can raise that, can enforce clean water, clean air, on behalf of the plants, as opposed to on behalf of the people. Is there a way to do that within our legal system? And yeah, so kind of the question does become, okay, so if we give animals rights, do we next give plants rights? And that, where some of these issues about ecosystem protection, that is kind of where they're going, is saying, you know, these are whole ecosystems, and it's not necessarily just the animals or just the plants or just the river that needs to have rights, but this whole ecosystem needs to have protected rights, and they need to be comprehensive.
Thank you. And for anyone interested in that area, remember that next week, Grant Wilson from the Earth Law Center will be talking about ecosystem rights. So it all works together. So we have another question. She said, I was wondering where animal rights stood on kill pens with regards to the protection laws.
So good question. A lot of that, well, you know, if you think of the animal rights movement as being animals shouldn't even be property, versus the animal welfare movement, you know, that is working within the current legal structure we have of animal welfare. So right now, certainly, animal welfare arguments would be against kill pens. Animal rights arguments also would basically, you know, if you go all the way to the idea of abolition, the idea of animals are not property at all, then animals would have the right to argue in court that those are cruel and unnecessary, and you know, against their interest and their survival.
Thank you. Mr. Keene, do you have any questions from the students?
Yes, we have a question from Trevor Sorbo, who asked, how could the monkey's rights, if any, ever be adjudicated if a human cannot sue for the monkey taking the picture to protect the monkey's rights to the photo he created?
Well, that is ultimately the problem, is what the court decided is the monkey can't sue. So if there were a point where the monkey were determined to be a legal person, then under the copyright statute, which applies to persons, the monkey could sue. Now, the interesting issue there in that particular case was with their decision about next friend standing, because, okay, so the monkey has standing, but basically what the court decided is that there's nobody that can determine the rights of that monkey and stand in for that monkey as next friend. So in reality, under that decision and under that particular statute, nobody can. There is no way for the monkey to sue. And that's where my argument that under other statutes, that might be different. Under other statutes, if the monkey were a legal person and maybe the court would decide that, oh yeah, humans can determine that, we'll take the Animal Welfare Act, that that primates do need to be in social environments. Humans can determine that. And so there can be a next friend sue on behalf of the monkey. That we haven't got there yet. So right now, yeah, the monkey can't sue. Ultimately, that case was settled, which, you know, settling is great, but it also, then the court doesn't, you know, a higher court doesn't have the opportunity to weigh in.
We actually have a follow-up on that. So someone asks, so for the monkey case, his only remedy for bringing suit would be if he was owned by an individual. And is that a correct assessment?
So that's an interesting aspect. Yes, if the monkey were owned by an individual, arguably then the individual would be able to sue, but the injury would then be saying, no, it's my copyright because it's my monkey. So it still wouldn't be and then you'd probably get into all sorts of interesting questions about works for hire and more about copyright law than I know. But yeah, so it still wouldn't be the monkey's rights, but the owner of the monkey.
Yeah. So we have another question. This actually came up in our Rights of Nature overview last week, and it fits in today just as well. I don't think we really came to a satisfying answer last week. So it says, if animals are given equal rights as humans or personhood, do you think that in Florida, where we are building on the habitat of black bears who are endangered, would it be possible for a person and their home to be removed from their property to restore the bear's habitat?
Well, good question. So if we think of, we'll take personhood first. So if the animals are granted legal personhood, then we next have to look at what rights do they then have. We often talk about animals having equal rights as persons, but that would mean they have the same rights as persons, and that doesn't entirely make sense because human rights they protect human interests, and animals have different interests, of course. Although some of the interests are the same, like the right to survival and things like that would be, those interests would be the same. But even if we look at saying, I'm thinking through this as I'm talking, so which doesn't always work well, but even if we say, okay, now animals have legal personhood, and they have the right to survival, so which would be a right to habitat, that this is where you're going to get into the balancing. And so I'm going to say, yeah, there is no satisfactory answer to this because it's going to be up to a court. So they say the right to survival is, both humans have a right to survival, and the animals have a right to survival. Is that going to mean that you have to remove the houses? And if you do think about it, now I'm thinking back to the red slider, what was the dam case? I mean that in the case about the dam. Where they couldn't build the dam because it would endanger an endangered species. That's kind of what a lot of endangered species cases are about. Interestingly, those are, and now you'd kind of even be elevating that because it's a right, not just something granted by a statute. So arguably, yes, but I don't know for sure because a court would have to do that balancing. I know, not a completely satisfactory answer.
That's sort of where we left off last week as well. Okay, so we actually, two questions that we got here, I think kind of both flow into each other. So I'm going to present both of them to you. The first one is there anything you think that can be done on the local level to make a massive difference? Are energies ultimately best spent changing laws on the federal level? The next question that we got was, my question is, it is easy to see why animals should have rights, and there are clearly ways to grant rights as we have seen in other countries. Then why not? Are there people or entities opposing animal rights, or is it just a matter of progressing the law and the judiciary in this area?
So I think absolutely yes, work on the local level is very important. And part of this goes back to, when I talked about Lawrence Tribe's article, and where he said that granting of rights is largely a matter of acculturation. And sometimes I think that is best done on the local level. And if you think about, and I bring this one up because it's one that I have worked on the local level, think about circus animals and all of the at least in the US and initially overseas, but in other countries, municipalities, and particularly initially municipalities and then states that have banned circus animals in their municipalities. And largely when you look at those discussions, I remember going to our city council, and a lot of it was individuals at the local level saying, no, we do not hold this ethic in our community. This is not a value in our community. As it then those kind of spread until they are kind of more ingrained. And the answer is yes, there are groups that don't believe that animals should have rights. They believe more in the talked a little bit about this, but they believe more that humans have a right to use animals. And they often talk about humans do still have to provide for the welfare of animals, but they have the right to use animals. And so they are often in opposition to those discussions, even at a local level, of providing any protections for animals. And sometimes it does become a slippery slope. I cannot tell you how many times I heard, oh no, if we ban circus animals, then the next thing they're going to do is ban rodeos, which is in Montana, you always bring up rodeos. If you want to argue against any animal welfare, you bring up rodeos. So yeah, they're still in our in our society are those opposing views. A lot of people in our society now are seeing that animals are sentient beings with their own inherent value. And that's where the animal rights and animal welfare movements as social movements are coming from. You also have another part of society that says, no, humans absolutely have the right to use animals in a variety of different ways, and that too is a social movement. So right now you kind of have a clash of social movements, and to the extent that those play out on the local level, I think that's great, because then they can play out on, say, the state level, and then on the national level as well.
Great, thank you. So we do have a hand here. Before we move to the hands, Mr. Kane, do you have any more? Have you received any more questions?
I haven't. We can move on to anybody.
Sounds good. Okay, well, Mr. Sorbo still has his, Sorbo, excuse me, has his hand raised. So I'm going to ask you to unmute and ask your question.
Yeah, and thank you for this presentation. This is great, and I appreciate you also saying you'll send us the PowerPoint deck, because this is a lot of great information, so thank you. My question is around more wildlife in particular, like, bears and other wild creatures. And I know you talked about that property laws. Property is sort of the majority view as to what animals are still.
Mhm.
So my question is more, if you're trying to bring a suit to, say, protect wildlife, how do you establish that I have standing, or that Animal Legal Defense Fund has standing, when to me it might be the property of the state of Florida but not necessarily me? So like, how do you establish standing? I feel like I have ownership of that animal just like everybody else, but how can you be successful with that?
Yeah, so that's an interesting question, and that's a lot of times has been really hard. Some of those cases have been more around the interest in viewing wildlife in their natural habitat. So they're less about protecting the animals, protecting the habitat to protect the animals, but in protecting the human desire to view animals in their natural habitat, which assumes protecting both the animals and that habitat from extinction. Those are interesting cases because you have to be able to show things like, yes, I always go hiking and want to view, and you have to show a pattern, and that you intend to keep on doing that, and that there is something that is now preventing you from doing that. But there are cases like, particularly environmental cases like that, that I think could be extended into the animal arena. And in fact, so one of the things I have that I will send you, one of the readings is a book, What Can Animal Law Learn from Environmental Law? And the first chapter is about standing and taking environmental standing cases into the animal realm. Disclaimer, I wrote that chapter, so I do have to give you that disclaimer. Writing that chapter is what made me think that standing is the hardest legal concept there is, especially environmental standing. But yeah, it is very difficult, because the only way to do it is to be able to show a human interest, and that you personally have an interest, kind of regardless of who owns those animals, that you have an interest that has been injured by say their disappearance or their endangerment or something like that.
Okay, thanks. Not an easy question, I guess, but thank you. That's interesting.
Okay, great. And amazingly enough, that has brought us to right on time at the end of our session.
Wow.
So this was wonderful. So yeah, everyone, please join me in thanking our speaker today for such an informative and thought-provoking session. I think that we had a lot of great questions come from this. Yep. And received a lot of great answers. So we're currently determining the best platform to make the recordings of our sessions available to you. So we will be sending out more information about that soon. I know a couple people have asked there. So we'll be getting in touch on that. And then again, be sure to join us next week when Grant Wilson from the Earth Law Center joins us to talk about ecosystem rights. And then on the 30th, we're going to have Professor Nadia Ahmad, who's going to talk about human rights or environmental justice. So we're going to get everything under that umbrella of what the rights of nature is. So we hope to see you then. And our session has now concluded. So thank you so much for joining us, and have a great weekend.
Thank you.
Thanks, everyone.
Thank you so much.